have the indictment, please? The indictment, the charge? Yeah, thank you. Just so if there's any students in the audience, I assume you're all students, ordinarily I would retire to my chambers for at least 15 minutes to review my notes and give a more coherent judgment. Because of the time constraints, I won't do that. Mr. O'Brien is charged that on or about the 12th of June in count 1, in effect punched Officer Fantasia, causing bodily harm to him with being the injury to the jaw, and further that he assaulted Officer Fantasia while he was engaged in the execution of his duty. Anytime the accused testifies, as Mr. O'Brien did, although an accused never has to testify, once the accused evidence conflicts with the Crown's evidence, the case of Regina versus WD has to be addressed. Regina versus WD says that if I believe the accused, that ends the case and I must acquit him. Now, the accused said, number one, he was walking in the park with his fiancée, saw the confrontation between Officer Fantasia and Mr. Freddie Friedbrain, intervened as a good Samaritan because he thought Freddie was losing the fight and didn't know that Officer Fantasia was a police officer, and only punched him in what he apprehended to be some danger when Officer Fantasia reached into his pocket for what Mr. O'Brien perceived might be a weapon. And it was only later that he learned that Fantasia was a police officer. Well, if I believe that in accordance with the Supreme Court of Canada's decision in WD, then the case is over. I believe I must acquit. And what that means is on any essential element. So if in respect to the punch, if I believe Mr. O'Brien that he was acting in self-defense because he anticipated some aggressive move by the officer, then that case is over. That count is over. I must acquit. If I believe him that he did not know that Fantasia was a police officer with respect to count 2, then the most I could convict him of is assault, because I would have to acquit on the essential element of engaged in the execution of his duty, because the accused has to know that. For the purposes of this exercise, I don't feel that I should make any credibility assessments, because they're all actors, whether they're actors in the drama club or the drama faculty or the law faculty, I don't know. If I don't believe Mr. O'Brien, but his evidence, the second branch of WD is if I don't believe his evidence, but his evidence may raise a reasonable doubt on the same issues, on each essential element of each offense, then I again must acquit him. And then finally, on the third branch, even if I reject his evidence and say I don't believe a word he says, but on all of the evidence which I accept, I have a reasonable doubt, for instance, about whether he committed an assault in count 1. I don't believe that WD attaches to the whether or not it's bodily harm, although they're you might say, because there's not really conflicting evidence, that's more of a legal interpretation of whether the injury suffered by Officer Fantasia amounted to bodily harm. But again, whether on all of the evidence, I have a reasonable doubt in count 2 that there was an assault. If I have a reasonable doubt on count 2 with respect to the third branch of WD, I must acquit. I could convict on count 2 of assault, but have a reasonable doubt on branch 1, 2, or 3 of WD that that Mr. O'Brien knew that the officer was in the execution of his duty. If I had to make a credibility assessment disregarding that any of the witnesses, one witness is a better actor than the other witness, on an objective basis, I might say that I am not able to believe Mr. O'Brien because of the submission that Mr. Houle made. Number one, wait a minute. You go through this park, even if I accept that you had to get through this park from where you went out to dinner with your girlfriend to get back to your house, let's face it, you know what goes on in this park. You know that there are drug dealers. One might assume that if there are drug dealers, they have weapons. You have your fiance there. Are you really going to intervene when you got your fiance there, when you know what happens in this park? A very good submission by Mr. Houle as to whether or not, if you were the jury, you would believe that he was as lily white as he claimed to be, especially once Mr. Houle brought out that he's a member of the coalition. There's nothing wrong with being a member of a coalition. Some of you may know my daughter. If there was such a coalition, she would be in that coalition. So there's nothing wrong with that, but at least it shows that he might have an animus either toward, he didn't know Officer Fantasia, but he may have had an animus towards police officers in general, especially when he sees a confrontation between a police officer and a private citizen. So on that basis, I may not be able to say I believe what Mr. O'Brien said, even though he was a pretty good actor. And not to mention his record, not to mention that he says, I'm not totally a friend of the truth, and I don't like Fantasia. So he not only has animus, and then on an actual basis, when Mr. Houle put to him, wait a minute, it's one thing to say Fantasia framed you on the 6-year sentence. Are you saying that you're not guilty of any of these? You deny even though they're, and I think if this were a real trial, he would have said, I think he'd have been entitled to say, did you plead guilty? And if you pled guilty, do you still not believe that you're guilty? Well, that would have greatly affected his credibility in front of a judge alone or in front of a jury. But then on the second ground, in this case, again, I'm sorry, I said it was Mr. O'Brien, it was Freddie who did that. Freddie's evidence, before I accepted Freddie's evidence, I would have to look for confirmatory evidence. But in this case, there was, because my notes say that Officer Ugart said the first physical contact was between O'Brien and Fantasia, was Fantasia putting his hands on on Freddie's shoulders. I do not agree with Mr. Houle. I don't believe the only time an officer can touch a person, I think in the context that Mr. Houle was submitting, was symbolically to effect an arrest. Supposedly, you're supposed to put your hand on the person's arm or shoulder and say, sir, you're under arrest. I don't believe, and on Fantasia's own evidence, he was not arresting Freddie. On his own evidence, he said, I'm not sure I could have told him to get out of the park, but I wanted to do it for my own safety. So on that evidence from the police, I might have had a reasonable doubt. On all of the evidence, Fantasia made a couple of mistakes in the sense of saying, well, I knew I wanted to get him out even though I wasn't sure I had the authority to tell him to get out. A more experienced police officer may have said, you know, Freddie, you're in a park where you're on parole for drug dealing. You're in a park where drugs are being sold on a regular basis. You know damn well that there are drugs in this park. I don't care if you're coming from an NA meeting. If you don't leave, I'll be reporting that you were near this drug-infested park to your parole officer. That should have been enough to get any reasonable parolee on his horse going the other way. But on all of the evidence, including the evidence of Mr. O'Brien, his story might reasonably be true because, and might reasonably be true, may not be a good way to invoke WD, because I don't think the onus is on, there's no onus on the accused, but that might be too high a standard. On all of the evidence, Officer Fantasia said, well, I'm not sure he did hear me when I said, I'm a police officer. Certainly on Officer Fantasia's evidence, he said, he may have said that with regard to the pulling off of Freddie, that he may not have had time to process that evidence. On Mr. Hoole's submission, which was again a very good submission, his position would have been okay on the pulling off in the execution of his duty, maybe, but by that time he had to know that Fantasia was a police officer. He had no justification to punch him. And if I reject all of that evidence, then he's guilty of at least assault, maybe bodily harm if I found that and I agree with Mr. Hoole's submission that a couple of years later, if he's still having some problems with his jaw, as long as it's related to the punch, that would take it out, or might take it out of trifling and transitory, and therefore could be bodily harm. But on the main issue, that by that time, even if he didn't have time to understand that Fantasia was a police officer when he was pulling him off, by the time he punched him, he knew damn well that he was a police officer. Then if I reject his evidence and I reject all the other evidence and find no reasonable doubt that the Crown has negatived everything, you did know, or prove beyond a reasonable doubt, you did know he was a police officer, you did punch him without justification, and it did cause bodily harm, then on all three branches, then I could convict. And I think that's my judgment, because I don't want to, I'm not an Academy Award person, and I'm not a good judge of who's an actor, a better actor than the rest. But I will say that I think all 4 witnesses did an excellent job. I would have in the judgment addressed the fact that Mr. Marley was there was no obligation to call the girlfriend on behalf of the accused, although it might have been helpful, that it was always the Crown's obligation to prove the case beyond a reasonable doubt. Once a defense was raised, it was not the defense's obligation to establish that defense, it was the Crown's obligation to negate it. I can't leave without thanking Mr. Hoole and Mr. Marley for really doing an excellent job, as they usually do when they're in my court. So that's my judgment.